Hello everyone, welcome to Crystal Diaries. This is another video of a series of videos relating to law of contracts in India. And in this video, we are going to learn about the agreement by way of wager. And before we begin this session, please do bring your Barrack and a notebook with a pen so that we can read the Barrack simultaneously and we can note down every important point whatever we discuss here. So let us begin. Section 30 of the Indian Contract Act states about the agreement by way of wager. But before that, let us understand what is wagering agreement. An agreement between two parties under which money or money's worth is payable by one party to another on the happening or non-happening of an uncertain event is a wagering agreement. And what does section 30 says? Section 30 says that agreements by way of wager are void and no suit shall be brought for recovering anything alleged to be won on any wager or entrusted to any person to abide the result of any game or other uncertain event on which the wager is made. So it says that the wagering agreements are void. What do you mean by wagering agreement? These are generally the betting agreements. If you are into betting or like gambling, all those things, those are termed as wagering agreement. So it says that such agreements are void. And secondly, it says that no suit. So even if you are winning any amount by the way of wager or by the agreement by way of wager, in that case, the other person, if he does not give you any kind of money or the winning amount, in that case you cannot move to the court of law in order to recover the amount. Okay, so let us understand this with an illustration. A says that it would rain on 1st January and B says that it would not. Both agree that if it rains on the 1st January, B would pay rupees 100 to A, and if it doesn't rain, then A would pay rupees 100 to B. So this is an example of agreement by way of wager. So in this case, if it rains on 1st January and B does not pay rupees 100 to A, can A recover the same amount from B? No, because it is a wagering agreement. So in this case, the happening or the non-happening of an uncertain event decides whether one person is to pay another a certain amount of money or not. And since this comes under the way of wager or wagering contract or wagering agreement, to be very specific, so this is not what? Recoverable, and it is void. So in order to understand what constitutes wagering agreement, let us look at the essentials of a wagering agreement. There are 3 essentials. The first, parties have opposite views regarding an uncertain event. Now let us understand this with the previous illustration. In the previous illustration regarding rain, here A said that it would rain and B said that it would not rain. So here there are opposite views. One is saying that yes, it would rain. The other one is saying no, it would not rain. Then the view is regarding an uncertain event. What is the uncertain event? Raining. So we do not know whether it would rain or not. The second essential is that there are chances of gain or loss to the parties in the determination of the event, one or the other. So in this case, A has 50% chance that it would rain and B also has 50% chance that it would not rain. So both are having chances. Now third one is parties have no other interest except winning or losing the bet. So do they have any other interest here apart from recovering rupees 100 from each other if they win the bet? No. So this is another essential. So this was the general rule regarding agreement by way of wager, which is void. Now there are also exceptions to this. Now let us learn what are the exceptions to the agreement by way of wager which are not void in nature. Now the first example or the first exception is the contracts of insurance. Now the contracts of insurance is not same as wagering agreement. although both are dependent on something uncertain future event, but it is not the same. The factor that distinguishes a wagering agreement from other valid conditional contracts like contract of insurance is that in an insurance contract, it is necessary that the person affecting insurance must have insurable interest in the subject matter insured. Insurable interest means an interest in the existence and the preservation of the thing insured. Okay, so in this case, there is insurable interest in the life or property for which we do an insurance, and not on the other thing or not on the money only that would be recovered, but the life or the thing on which we are investing money or for which we are buying any insurance policy. Now the second one is horse race. So in case of horse race, if the prize money is rupees 500 or above, then it is recoverable. So horse race is not a game of chance but a game of skill. It depends how you have treated the horse, how you have trained the horse, how you have fed the horse so that it can perform well in the horse race. So it is also not a wagering agreement, and if the prize money is more than rupees 500 or rupees 500, then it is recoverable. Now let us see a case law, that is K.R. Lakshmanan versus State of Tamil Nadu 1996. In this case, the Honorable Supreme Court had held that horse racing was a game of skill and playing for stakes in game of skill was not illegal. And also, it has also been provided in the very section that nothing in this section shall be deemed to legalize any transaction connected with horse racing to which the provisions of section 294 capital A of the Indian Penal Code applies. Okay. So it also expressly says that if 294 capital A, section 294 capital A of the IPC relates to any kind of horse racing which has been declared to be illegal, in that case this section shall not apply. Now the third one is game of skills. So in case of games of skills which are competitive games or sports games or crossword puzzles involving skill, these are not a wagering agreement. Now the fourth exception is contribution to chit fund. In chit fund, there is a chance of rain, but there is no chance of losing as the actual subscription amount will be returned. So there is no loss and the mutual chance of losing or gaining is absent. Therefore, chit fund is not a wagering agreement. So with this, we complete section 30, that is agreement by way of wager. We also look up to some of the exceptions. I hope you were clear with the very section 30 and its exceptions. And till I bring the next video, keep revising and take care. Bye bye.